There it is. There's going to be so much good information today, but I don't want you to give yourself a hand cramp getting all your notes down. So we're going to be recording. You're going to get a copy to that recording to review later on, and maybe share with your loved ones, or make sure you catch anything you might have missed the first time. So hopefully that means you can just kind of sink in and soak up the information and not stress too much about missing something important. We also have a pretty robust webinar library on our website and on our YouTube channel, and we have some videos hosted on SPL's channel as well. So you can watch presentations like this, kind of in this realm of subjects, and expand your knowledge even further if you'd like. And we know that this is going to be something where folks have lots of questions. So we're going to go ahead and have you hold them until the end, but Liberty is excellent about sticking around to make sure there are no questions unanswered. And since there is so much stuff to cover, we know that it might be a little tricky to kind of figure out exactly what your question is. So if it's like 8 o'clock tonight and you're washing your hair and you think, oh, I have a question, we're going to make sure you know how to reach us at People's Memorial, as well as Liberty and her colleagues at KHBB Law, to follow up with them to get those questions answered. So this won't be the last time you hear from us. We remain available to help you in whatever way we can. So if this is your first time hearing about People's Memorial, I thought I'd give you a little bit of information about our organization and the work we do in the community to kind of help you understand why we're here. We're the oldest and largest memorial society in the US. We just turned 85 and we were founded right here in Seattle. So we keep a pretty low profile, but I think we're doing pretty good for our age. And we provide funeral education and consumer advocacy support to all Washingtonians. Over 220,000 folks have become members over that history. Of those, about 71,000 of them are currently living. So as you can imagine, our modest staff of 4 stays very busy. But it's work worth doing. We're really excited to be able to be working in these educational and advocacy spaces. We offer tons of community education like this. We host a bevy of free resources on our website, our Facebook, our Instagram. I'm trying to get us an intern to help us learn the ways of TikTok. But as you might imagine, funeral professionals aren't the most skilled at dance choreography. So be patient with us as we branch out. That advocacy work we do is so important and often quite challenging, but really important in supporting our state level legislature in increasing funeral choice, as well as increasing price transparency in a notoriously opaque industry, funeral industry. And, if you've spent more than a minute up here in Washington, you know that we are blessed to have an incredible diversity of peoples up here. And everybody deserves equal access to the important social and cultural and religious practices that go along with mourning and celebrating the lives of those we've lost. And with those, equal access to affordable cremation, burial, aquamation, and natural organic reduction. So kind of some big goals here. We stay busy. As Emily alluded to, this is part of a series. Last week I was here presenting about funeral options, and I'll be back next week with a colleague from End of Life Washington. We'll be talking about advanced directives for healthcare. And if you can't make it, you can hop online if you'd like, or you can register and still receive a copy of that recording right to your email from Emily. As Emily mentioned, she is our older adult program manager. Are there any announcements you'd like to share with patrons before we head into the presentation? All right, awesome. Well, Emily's going to be your point person for future education. She does great work. All right, the real reason we're here is to get some excellent information from my colleague, Liberty Upton. She's an attorney over at KHBB Law. And I think I'm going to go ahead and just hand it over to you and let you just bathe us in wisdom. All right. All right. Do you want to be over there?
Oh, either way, it's not.
Oh, okay. Perfect. Wait, where'd it go? It's not? Okay. Let me try one more thing real quick.
I was gonna say, do we need to switch the share?
I think so. Oh my gosh. That was scary.
Switch to camera view for a moment.
Okay. I tried that.
Okay. So you can't see me on video, right? Okay, great. This is gonna be a real weird profile as I talk out to everyone here. Okay, so hello, I'm Liberty Upton. I'm an estate planning and probate attorney at KHBB Law in Seattle. My focus is completely dedicated to that work, and that is what I went to law school to do. So it's the only law I've ever practiced. I view estate planning as one of the most loving things you can do for the people you leave behind to have things organized. So that is my job, is to help put down whatever somebody's wishes are so that it's clear to the people that they leave behind. So today we're going to go over what some kind of foundational estate planning documents are. So where we're going to start, and this is kind of our roadmap for the day, and some of the things we won't cover because they're going to be touched on by other people, either Beverly last week or whoever's presenting next week. But we're going to talk about durable powers of attorney. We're going to talk about wills or revocable living trusts. We're not going to discuss healthcare directives or directives regarding disposition of remains because those are covered in other areas. But these are what I treat as kind of a core foundation estate plan. This is something that I think everyone needs regardless of, their level of wealth. Everyone has an opinion on what they want to have happen to them if they're either alive but incapacitated or eventually upon death. So we're going to start with kind of a legal term that you might hear, which is a fiduciary. So a fiduciary is a person or an organization who is going to put somebody else's needs above their own. Their job is to manage things on behalf of another person. So this can sometimes be a family member, this could be a friend, this could be a professional that this is their job to help manage things for other people. This is going to come up in kind of several different ways throughout documents. So in a will, the person who's a fiduciary is sometimes called a personal representative or an executor. In a trust, the person who's a fiduciary is called a trustee. And in a power of attorney, that person is called an attorney in fact or an agent. So just know that broadly speaking, when we're talking about those roles, it's somebody kind of either stepping into your shoes to manage things on your behalf, either during life or upon death. So they have different terms, but the goal is kind of the same, as to manage things for somebody else. So when you're deciding who you should name as a fiduciary, this is a very important role. And so we need someone in this role who is going to be able to communicate your wishes clearly on your behalf. They need to be responsible. We don't want to give somebody control of our bank account if they're just going to go willy-nilly and spend it on whatever they want. It needs to be in your best interest. We ideally would like them to be in a location where it's easy for them to act for you. Now, that's not to say if the person who's the closest to you in your life is your sister who lives in Chicago, she still might be a good person for this role. But sometimes having people nearby is definitely helpful in kind of managing things for you, or at least has the ability to occasionally come and see you. This person should be at least over the age of 18. I have a surprising amount of people who want to put their kids in this role and their kids are still teenagers, but it's who in their life they trust. But we can't have anyone under the age of 18. And honestly, I don't recommend anyone under the age of 25 be in that role. Our brains haven't fully developed until that point. And frankly, that's just a lot of pressure to put on somebody who is a very young adult. So at least over the age of 18, ideally over the age of 25. And then, we do get in kind of the older age of, if there's, you might want to put your parent in a role, but if there's a dementia risk or things along those lines, sometimes people age out of the role in which you might want them to be able to act on your behalf. This is not a blessing we're bestowing on someone saying, I'd like to designate you as this person. This is a lot of responsibility. And it's not a job, it's a job they can charge for, but they're not going to get rich off of. So it's something that we want to make sure that they can handle the pressure. They have the space in their life to do this kind of job. And that they can handle the pressure of potentially sometimes even making life and death decisions. This person, it can be a professional, it can be someone in your world, but you kind of want to stress, their strengths and weaknesses and see, is this something that's a good fit? And often it's nice to have a conversation with that person before you just plug them into your documents. So like I said, this can be different types of people can serve in this role. Usually a family member or a friend is going to be the least expensive option but also the person who has the least experience in this role. Keep in mind, they don't need to know how to do everything. They get to hire help and use your money to do that, right? They get to work with an attorney, a CPA, financial advisors, whoever they might need. But they themselves, as they're doing this work, are probably not going to charge more than $25 an hour for most of the work that they do. Above that, we get to an independent or professional fiduciary. We have a lot of companies in the state of Washington that are local, and they have professionals that are doing this sort of work. They're going to charge a higher fee, obviously, than a family member or a friend, because they are professional and this is the work that they do. So that you get the benefit of the knowledge that they do this work, and there's a cost that goes along with that. Additionally, attorneys and CPAs will sometimes serve in this role. I personally don't. I have a hard enough time doing it just for my family members, so I don't do it for my clients, but there are some people who do. So if that's something where you know you don't have someone and you trust your attorney and you want to do that, that's something you can definitely ask them to do, and some do and some don't. Same thing with CPAs. A lot of times they will have a professional fiduciary business as well. Banks and trust companies are going to be the most expensive, but again, you also are getting, the professional advice and management and things along those lines. A lot of times they're going to charge a fee based on the amount of assets they're controlling. And banks and trust companies a lot of times won't serve in all of the fiduciary roles. So when we think back, we talked about personal representative and trustee. A lot of times they'll serve as trustee, but not personal representative. So if you're thinking of looking at a professional, you want to make sure that they're able to serve in all of the roles where you actually need someone to be a fiduciary for you. So the first document we're going to tackle today is a durable power of attorney. So a power of an attorney is a document that's effective during your lifetime. Usually it's something where we want it to continue past incapacity. So if you get into a car accident and you're in a coma, or, eventually Alzheimer's or dementia are involved, we want somebody to kind of step in and manage things for us. This document could also just be for a limited time. Say you're out of the country and you're selling your house and things got tripped up and we need somebody to step in and just make sure that deal still goes through. Sometimes powers of attorney are for a very specific and limited purpose, but for the most part, people need powers of attorney for the just in case something happens and you need somebody to step in and manage things. So sometimes people will do a power of attorney that's combined for finances and health, and sometimes people will do it where it's split up. A lot of times we want different people for those roles. They're different skill sets. Somebody managing your finances and making sure your bills are being paid on time is a different sort of skill than having the emotional intelligence to talk to your doctor about specific medical decisions. Oh, you're fine. So the durable power of attorney is going to appoint someone to manage your finances and manage your healthcare decisions when you can't make those decisions on your own. This document can be effective immediately. For healthcare purposes, it needs to be. We never know when that's going to come into play. There's usually a HIPAA waiver in there that allows doctors to communicate with your agents so that they can make decisions on your behalf. For financial purposes, it can really be effective when you want it to. So some people choose to have it effective immediately when they sign it so that there's no question. We trust this person. We want them to be able to act no matter what. Some people don't like that feeling of like, ooh, if I'm alive and I can manage my things, I don't want somebody to have that power to step in. So sometimes they'll have it effective upon incapacity. So incapacity is you can no longer make decisions for yourself, and we need a doctor to confirm that and say so in writing before anyone can act on your behalf. It gets challenging sometimes to get people to a doctor and to have the doctor say that they're incapacitated. So that can definitely cause a lag in time. And some people want that. They view that as a safety net, and other people view that as a hindrance. And they call me saying, what the heck? Why can't I use this document? So it is something to really think through and to have a discussion on of, if you know this person and you trust this person, especially while you do have capacity, don't you want to see if they can handle this role and handle that trust and responsibility? I generally, at least for spouses, try and encourage people to make it effective immediately. For, another family member or professional, you may or may want that to be effective upon incapacity, but they're all valid options. And it's a discussion to have with an attorney and with the person that you're putting in this role, frankly. So the definitions of incapacity have been up on the screen. I'm not going to go into those. You can always go back to kind of see what we define as incapacity, because some of it might be intuitive and some of it might be, lost in a, you're detained or in a different country and you can't be found, that sort of thing. So it can mean different things. A power of attorney is a document that must be signed and dated and acknowledged either before a notary or two disinterested witnesses. So you can't just have your kids come over and sign with you. That's not going to work. This needs to be done either with a notary or people who are not involved in your estate plan in any way. And it needs to be signed together. So it's not that you can just sign it and then go take it to, your nearest notary and say, I signed this. You have to actually sign it in their presence. A will. So what we just covered is what's happening during your lifetime. A will is a document that does not become effective until your death. So it can be changed at any point during your lifetime as long as you have the mental capacity to make that change. I frequently have, children reaching out to me with older parents who do have a dementia diagnosis or things along those lines. And capacity to draft a will is different kind of than other capacity that we might think of. So a lot of times I'm having conversations with people that are just a chat of, hey, tell me who you are. Tell me who you're married to. Tell me who your kids are. Where do you live? What do you own? That sort of thing. So as long as somebody can tell me who they are, who their people are, what they own, and what they want to do with those things, we have capacity to make a will. So, it may not be too late. It may be too late. I've met with plenty of people that meet that challenge, but then can't actually make a decision about what they want without somebody kind of prompting them. So it really just kind of depends on where people are at. But the goal is not to wait until we're in that situation. The goal is to, while you know what you want, record your wishes and know that you can update it later on if you want to. A will is going to provide a basic roadmap for what happens upon your death. Somebody is going to step into your shoes to essentially wind up your affairs. They're going to gather all your assets and pay your creditors and eventually distribute assets pursuant to whatever it is that you want. A will is going to be filed with a court upon death. This is the process known as probate. Probate gets a really bad rap. If you do any sort of research on your own and listen to any talking heads on TV, they will tell you to avoid probate. And frankly, that is nonsense in the state of Washington. So Washington actually has a really straightforward probate system, especially if you have a properly drafted will that says my person can serve without bond and without court intervention. So bond is basically where they wouldn't have to put up any money to say that they can handle your estate. And court intervention is when you have to go to court to get permission to do things. So as long as we're waiving bond and saying no court intervention, it's a relatively straightforward process. Where probate gets a bad rap is kind of odd family dynamics and fights that exist, whether or not we're going through probate or some other process. So hopefully, if nothing else, you come away with probate in Washington is okay. It is not a process to be feared. It is something most people are going to go through. Other states, however, are not so easy. So California is the one we pick on the most. They have a terrible system. The court is involved every step of the way. Attorneys get paid based on the size of the estate, not on the actual work that they do. So they are the nightmare system that we want people to avoid. So when the talking heads are on TV saying, avoid probate, you shouldn't go through probate, it's because of states like California, and they're on a national audience. And there are states that do exist that have poor systems in place. Washington's is not a poor system. Requirements for a will is that it is in writing, signed by the person making the will. That person is known as the testator. And it is signed in the presence of, so again, not signing and taking it later on, but in the presence of two disinterested witnesses. So not related to you, not involved in your plan in any way, shape, or form. So I kind of already went over this. I jumped ahead of myself. But probate is the court supervised process of settling the deceased person, who we refer to as the decedent's estate. So the person who does this, if there is a will, is going to be called the personal representative or the executor. And what's going to happen is when someone dies, we get their will, we get their death certificate, we submit them to the court and say, this is the person that is being appointed as the personal representative in the will. They agree to sign, and the court issues what's called letters testamentary. I don't even go to court to do this. This is all submitted online. I mean, the will has to go actually in person, but it's submitted online via the clerk of the court. So we're not arguing in front of anyone. There is no reading of the will. None of that is happening. It's a pretty straightforward process. If we take the document, the court says, great, as long as they're willing to serve and they don't have any felonies or anything along those lines, the court gives them what's called letters testamentary. And so that is the document that you go out into the world and say, this person has died. I need access to their bank account and their records and all of those type of things. If a person doesn't have a will and they don't have a trust, they die intestate. And in an intestate administration, it's roughly the same process, but the person is known as the administrator of the estate, and they get letters of administration. So in dealing with banks and everything along those lines, this is what they're used to. If somebody dies, they're going to want the death certificate and they're going to want letters testamentary or letters of administration. The personal representative, like I said, they're going to gather all the asset information. They're going to notify and pay creditors. They're going to file tax returns. So we have final income tax returns and we may have estate tax returns. If we have time, I'm going to get into estate taxes, but just for now, putting out a blanket statement that in Washington, any estate over $2.193 million is subject to estate tax, and we have to file an estate tax return. So even if the entire estate is going to a wonderful charity like Seattle Public Libraries, we still have to file a tax return reporting that date of death snapshot value. And that includes more than what you think it might. It includes life insurance, it includes your house, it includes retirement. Everything you own is included in that date of death snapshot value. So the personal representative is going to be in charge of making sure that that gets filed if necessary. And then eventually, once we're ready to wrap all the things up, we know what the values are, we've paid creditors, we've paid taxes, we know where things go, they're eventually going to distribute the estate pursuant to whatever you've laid out in your will. Certain assets that are not subject to probate, and these are, conveniently titled non-probate assets. Very clever name. This include assets that are titled as joint tenancy with right of survivorship. If you are married and have a bank account, that is most likely how the bank set it up. Property held in a trust. I'm going to go over trusts in a little bit. Life insurance policies, proceeds, anything that's labeled as a transfer on death or a payable on death, that's subject to a community property agreement. And then things with beneficiary designation. So things like retirement accounts. So they're included in your estate for estate tax purposes, which I was talking about, that $2.193 million number. But they may not pass through your will. They're going to pass to kind of whatever the designation there is. If there's a beneficiary designation or a pay on death, they're going to go to whoever is under those designations. A revocable living trust is a will substitute. So this document is something that can be changed during your lifetime. It's sometimes called revocable, revocable. It's the same word. It means the same thing. People will correct you on it. Who cares? Kind of a thing. So a lot of times this is shortened to an RLT is what we usually call it. So it's a will substitute in that it's going to do roughly the same thing as a will, and it can be changed anytime. The difference is this needs to be funded during your lifetime in order to work. And the work in quotes there is avoid probate. So like I said earlier, non-probate assets include assets in trust. So if the goal is to avoid probate, which again, is not a scary process in Washington, but some people still want to avoid it, you actually have to move all non-probate assets. So things like bank accounts that aren't joint tenants with right of survivorship, your house, your car, all of those type of things need to go into the trust in order to avoid probate. Contrary to popular belief, this is not any sort of asset protection. There is no tax planning involved just in having a trust. It is kind of just like putting a box around you and saying, I, Liberty Upton, now am the trustee of the Liberty Upton Trust, and I've put my property in there. So it can still be useful for people who own property out of state or who desire some sort of privacy. So a will is filed with the court upon death. A trust is not. So whenever a celebrity dies and you know exactly where their things went, it's because they had a will or they didn't plan. If they had a trust and we don't know who got what, that is why. So just like with a will, the personal representative, a trustee is going to have roughly the same job. They're going to gather asset information. They're going to pay your creditors. They're going to, pay taxes and then eventually distribute your estate pursuant to the terms of the trust. Now we're going to talk about what happens if you don't do an estate plan. Good or bad news. This is all going to be online, by the way. You don't need to go through that. The state of Washington or wherever you live is basically going to make a plan for you. You may not know it, but they've done it. It might be what you want. It might not be what you want. So a lot of the reasons why we do things like create powers of attorney is to have your personal autonomy. You are picking the person you want, and we're avoiding kind of a lengthy and costly court process if you don't name someone. So if you don't name someone, somebody in your family, one of your friends, a professional may have to go to court in order to get appointed as your guardian or conservator. So they might need to be able to make decisions about your care or your finances. And that's going to cause delay and more expense versus just doing a power of attorney and saying who you want to step in when you can't make these decisions. If you die without a will, again, that's called dying intestate. And Washington determines who gets to step into your shoes to wind up your affair and where your assets go. The administrator of your estate, if you do not plan, if you do not have a will, if you do not have a trust, is going to be determined by state law and is going to go in roughly the order that's here on the screen of we're going to look to see, do you have a spouse or are you in a registered domestic partnership? If so, we stop there. That's the person who gets to serve in that role if they want to. We can't force anyone to do any of these roles. These are all at choice. After that, we're going to look and see, is there a child or children who can serve in this role? And then there might be some disagreement about who steps into that role or everyone does it together. It gets a little complicated sometimes. And then we look at parents and siblings and grandchildren and nieces and nephews. If none of these people are able or willing to serve, then it might even be that somebody's creditor ends up stepping into this role because they want to get paid and they want to open probate so that they can make sure that they receive the assets they're entitled to. If you don't plan, and Washington plans for you, the diagram up here right now is basically what is the laws of descent and distribution in intestacy. So basically Washington saying, this is who's going to get your stuff if you don't plan otherwise. So this is right now for a single person, it would go to your children and then to your grandchildren and then to your great-grandchildren. And if we don't see anyone in that, kind of down your family tree, we're going to go back up your family tree and see if we can find someone. So we're going to look to see, are there parents? If not, then siblings, the nieces and nephews and grandnieces and nephews and down, down, down. So we kind of go down and then back up and then down and then back up your family tree to try and find someone. So again, the lesson here should be create a will so you can say exactly where these things go instead of relying on the state to figure it out for you. Distribution of an intestate, died without a will, without a trust, estate, if the person was single is what I just went through. So it's written out here versus just having a picture of it. If the person was married, it gets a little bit more complicated. So in Washington state, we live in a community property state, which a lot of people think means they don't have to plan because they consider everything to just be going to their spouse. Not what that means necessarily. So community property means you own things together and you can control half of it and your spouse can control half of it. You can always control your own separate property. So anything you received or had before marriage or received by gift or inheritance is considered separate property as long as it's kept separate. But anything you've created during your marriage, anything that came from your income earned together, it's going to be considered community property. So technically, yes, all of the deceased person's interest in community property does go to the surviving spouse, but there's still a mechanism to get there. It's not an automatic that it happens. So if you own a house together and your spouse dies, under the law, it does go to you, but if you don't actually make a deed to transfer it, then it hasn't actually occurred. So I frequently have plans where somebody died 10 years ago, and now the spouse is coming to me and we have to do a little bit of cleanup to make sure that they actually own the house in their name under Washington records, essentially. So it's not automatic, but per law, yes, it does go to you. We just might have to do some work to get it there. Separate property, again, that was anything that owned before marriage or received by gift or inheritance, or if there was some sort of prenuptial agreement stating things are separate property, that 50% of that would go to the spouse and 50% of that would go to descendants if they were survived, or we might have some other kind of combination if there are no children, but there are parents or siblings or something along those lines. So again, the lesson here is do what you want in your will and don't rely on the state of Washington to decide where things go, because this is where people get in fights and get frustrated and don't understand the process. Taxes. So like I said, mentioned before, the Washington exemption is 2.193 million. So anything under that, we are paying zero tax. Anything over that, there will be a tax assessed depending on where the assets are going. There are certain times where even if the estate is over that amount, if everything's going to a surviving spouse or everything's going to charity, we might not actually have to pay any taxes, even though we have to file a tax return. Federal exemption right now is $13.61 million. It's indexed for inflation. Next year, that is going up to 13.99 million. Unfortunate that they didn't just let us go to an even number of 14, but here we are. If your estate exceeds those amounts, you're going to want to talk to somebody about tax planning and trying to minimize those taxes. And there is a credit for if you are over in Washington and pay taxes, there is a credit for that for federal tax purposes. So this is a complicated diagram. This is not something to necessarily be gone through in depth at this point. But this is to basically show you kind of how we pay tax once we're over a certain dollar amount in Washington. So under 2.193, again, we're not paying anything. But once we go over that, if we're over by $1 million or less, or 3.193 million, then we're looking at different tax kind of brackets in here. So this is breaking that out. Federal tax, there is a bracket, but for all intents and purposes, it's basically a 40% flat tax. Once you're over that next year, 13.99 million. So we often minimize taxes with irrevocable trusts. So not to be confused with the revocable living trust I talked about earlier, which can be changed at any time. Irrevocable or irrevocable means it can't be changed. So a lot of the times we're doing this with people during their lifetime, getting assets out of their estate. And sometimes we're doing it upon death by setting up trusts for other individuals. We create trusts for many reasons, but the main ones are tax planning, creditor protection, control, and when the trust is lacking in the relationship where we don't actually trust the person to be able to manage their own assets. So sometimes this doesn't have to be a lot of money. It might just be for a minor child that we want to make sure someone's controlling things until they are adult. It might be for somebody who has a substance abuse issue and we want to make sure that there's money there to pay for their support, but we don't actually want it in their hands completely to be controlled. For trust provisions, truly, there's not enough time to go over how many different types of trusts there are or what types of trusts there can be, but you just know that there depending on your situation, if it's something of interest, it could be discussed of different types of terms. Who's in charge? When does the beneficiary step in? What types of distributions are we making? For the most part, we're making distributions for somebody's health, education, maintenance, and support. And that is going to cover a lot of different types of distributions. This is not an exhaustive list, but this just kind of covers what it is. We're making sure people's basic needs are being met, but it's more than just basic needs. We're making sure that healthcare expenses are being paid, and that includes insurance premiums and things along those lines. If we need rent to be paid or mortgage to be paid, things along those lines, a trust can provide for that. Especially for education, when we're talking about trust for minors, we want to make sure that this might get them through any sort of kind of technical school or college education, that the trust can pay for those sort of things. So they can be used for a lot of purposes. And trusts can seem a little restrictive. We're tying things up and purposely saying you're not controlling it, somebody else is, but there's a lot of ways that we can kind of give power back to people if that is of interest. So there are ways that we can plan with trusts to make sure that people are getting all of the benefits of the tax planning and the creditor protection, but they're still have some say over kind of what happens to those assets. So one of the ways that we do that is we say, okay, you're a minor now, but once you turn a certain age, your aunt's going to step away and you're going to step into managing your own money at that point. So that's one way we do it. And another way that we do it is we give people what's called a power of appointment. So we create a trust, it's tied up for some amount of time, but we say if you die while this trust exists, you can in your own estate plan say what happens to it. So when we give people assets outright, it's theirs. They can do whatever they want with it, just like you can do whatever you want with your assets. When we put it in trust, there's restrictions on what it can be used for. So this is just giving them some power back to say, okay, during your lifetime, you didn't have much control, but if you want to give it to your spouse upon death, or you want to split it unequally between your children upon death, you can. So there's a lot of reasons why we don't want things to just go to kid and then equally to grandkids. We might have a grandchild with special needs that they're going to need more money during their lifetime. And so we want to split things 60-40 or something along those lines. So it's helpful to give people back some power and control eventually. So I know that was a lot of information. I wanted to save time for questions at the end. I'm happy to go back to any slides or things along those lines, but we're here. Jump on in. Yeah.
To leave something to a sibling without it going to that sibling's children, if the sibling has passed away before I get my will updated, removing that sibling as their heir.
Okay. So sibling died.
Yes, yeah, so they're leaving something to their
sibling.
To
their sibling.
Their sibling, if the sibling passes away before they do, how does it not just go to their children?
Then they need to update their will at that point to state that it doesn't go to that person. For the most part, when we're doing estate plans, it may or may not be the case. So we're specific in our language where I say, I, Liberty, leave to my sister. And if my sister is not living, to her descendants, usually that's going to be by right of representation or per stirpes. So we're not even just looking at my sister. We're saying we're looking at my sister and seeing if any of her kids or their kids are living. So a lot of times that's the language that will be there. Sometimes language will cut it off at, I leave this to my sister, period. If my sister's not living, this is where it goes. So we're looking to the language in a will to be specific for that. And if it is to my sister, or if she's not living, to her descendants, we want to go back and make a change to that, because otherwise, if you die in the meantime, it will go to sister's kids. Yeah.
Okay. So I know a lot of people are trying to avoid it. Is it because it's expensive? Is that one of the reasons?
It's
they already have it.
They try to avoid it because they hear horror stories, and it gets a bad rap on, the movies and the media, and like I said, the talking heads on television, things along those lines. So, and there are states where you legitimately do want to avoid it. The probate process itself is a hassle. So there are states where you might want to, but there in Washington, the probate process itself is not very difficult. There is an expense to it. The actual expense of filing the will with the court, a couple $100s. So it's not that great of an expense to try and avoid completely. It really just kind of depends on what you're planning with. If it's an appropriate thing to try and avoid it by doing, having beneficiary designations on everything or having transfer on death designations on everything. Yes, that can be an easy way to get things to people, but it's not as flexible. We're not creating trust for people. We're not doing any sort of planning like that. So it's going to be, if you're just giving it to your spouse, something along those lines, it might be appropriate. But then you lose the ability to tax plan or credit or protect. Some people, especially blended families, if you don't have the same kids and you want to make sure something's going to somebody else, you want that in a will. You want that in a trust. A bank document saying pay on death to my spouse is not going to get those assets to your children when your spouse dies. So probate, there is an expense to it, but the expense of actually figuring out date of death values and paying creditors and distributing assets, that's kind of exist no matter what. That's going to need to be figured out. So even if you completely avoid probate, if your estate's over that 2.193 million, we're still doing all of that exact same work. It's going to exist. So if it's under that, yes, it might be an easier or less expensive way to do it, but it's not as flexible and it's pretty limited in its function of just using the options to avoid probate.
Just updated the will. I'm the durable power of attorney, and I've activated the financial durable power of attorney. She has one major asset, which is her condo, and I want to protect that from. She's dementia. Got a boyfriend half her age.
Go, mom.
That's what I said. Where did I go wrong? And gambling issues. So I want to protect the asset because I actually paid off the house.
Got it.
So I want to protect that asset, but I don't necessarily, she has a car, she has little minor things I don't care about. Can I then put that in an irrevocable trust to protect the asset of the hope?
Potentially.
Okay.
This is going to be one of those you need to talk to an attorney sort of situations of deciding, are there other siblings, all of that kind of stuff.
I'm the only other sibling. I am the trustee of I am a trustee of the will. I am her only living child. My brother's deceased.
Gotcha.
So it's just me, my daughter, and two granddaughters.
Okay. And does your brother have any kids that are living?
My brother had no kids.
Okay. Yeah. So that might be something you can consider doing. Asset protection planning. That's more of a planning for, keeping her from doing something, right?
Yeah, I guess.
Yeah. So,
Protecting the asset.
Yeah. Well, I mean, is your concern basically that she'll give it to the boyfriend? Yeah.
Gambling and that being attached that are not now. There's no attachments. There's no the property title is clear.
Yeah.
Everything in her will says it goes to me.
Yeah.
Her will is very, very clear.
Yeah.
Daughter, everything goes to her. Blah, 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 blah. So I know there's advantage for me to wait, instead of transferring the property into my name now.
Yeah.
Yeah. Versus, so now I'm like, I don't want to do that, but my whole thing is it better than when you're really only trying to protect one asset? Her car's old. I don't know.
So there's a couple things at play there. So one is when you hold an asset till death and it's transferred, we get a basis adjustment based on the date of death value. And so for a lot of people, they really want to hold that asset, especially when we're talking a house that was purchased 50 years ago for almost nothing. The value of that house has changed significantly over time. And so if you gift that house now, the person who receives that gift gets the basis. So basis is what it was purchased for. So if you buy something for $10 and sell it for $100, there's $90 of gain. So that $10 is your basis. So when it comes to a house where we're talking bigger capital gains, that's a much bigger deal. And so gifting assets gets us carryover basis. But when someone dies, we do a basis adjustment to a date of death value. And so the person receiving that, all things being considered, would probably prefer to receive that when someone dies. When we're creating a revocable trust, we get into that issue of you're making a gift to a trust. So again, you need an attorney involved in this process and advising you on this process of, is it something that you want to do? Because once it's transferred into the trust, it is truly irrevocable and it cannot be changed and it cannot be undone. So it is a very serious thing to consider. It might be appropriate. It might not. Yeah.
So would she have to pay taxes on the difference between the purchase price and when it was?
If she's going to sell it, yes. Yeah. Oh gosh. Oh, sure. So that was a question about mom having dementia and having a condo that she wants to protect. And the question was, should it go into an irrevocable trust or not? I'm not going to go back through the answer there. The battery is running low. I don't know what's up here. Okay, any other questions?
We do have a question in the chat. Is there a general template for a for some of these documents that you've been mentioning?
I don't know where this goes. Left-hand side. Do we have an outlet?
If you want to pass that.
Yep. Okay, so yes, I am an attorney and yes, I get paid to do these documents. The cheap comes out expensive. So there are things that exist online. I'm not going to send you any of them because in my experience, I have come across them in probate. So when somebody actually dies and we are then using those documents, those are the ones that end up being expensive because a layperson drafted them and there was nobody giving them feedback on, that is a nonsense idea. You should not be writing it that way. So is it completely possible that something could work out from an online, create your own will sort of document? Sure, it could work depending on your situation, but there's nothing I'm going to advertise as being something you should go out and do. There are attorneys that do flat fee estate planning. So I bill hourly when I create estate plans, but there are attorneys that very straightforward, as long as you are not a person who has a taxable estate, you're not over 2.193 million, you're not trying to set up any complex trusts, anything along those lines, that they'll have flat fees of, you can get a power of attorney for X dollars, you can get a will for Y dollars kind of a situation. So there are lower cost alternatives out there. I would encourage that over going online and doing your own document.
Next question. I just love this. Okay. Going to leave the irrevocable trust and go to a revocable trust on the same thing. My daughter and I, we both own homes, both have, we're thinking about getting a revocable trust and putting our assets together under an LLC maybe and have an LLC run our, she's like, okay. So we're thinking about putting our homes, and I'm not even sure, do we need to even, so like I have a stock portfolio, let's say she has a stock portfolio. I have 2 grandchildren, they're young. We don't want the ex-husband to have any of those things. So we want to be able to, whatever, we may even hire them later as they get older to run the LLC, to run the trust. Yeah. Is that something that sounds better than just working off our wills and leaving like payable, transferable on death here or transferable? So my dad's stuff, everything is transferable on death. All his financials transferable on death. The house is in both our names.
Yeah. So the question is about doing a revocable trust or an LLC for a house or for stock portfolios. So an LLC is a business, and you really shouldn't be doing that unless you're doing something like running a business where you have a property that you're renting out to other people. Airbnb, or, you know, long-term rentals, things along those lines. For you personally, it doesn't really do much. It's your own house, you're living there. LLCs are generally used to minimize your exposure to risk. And so when you have somebody who's living in your home and may sue you, it is a way to minimize risk that they can't get to your other assets. They can only get to what's in the LLC. So for your situation, you're living in your house, no. Will or revocable living trust. There is no difference in doing that unless you tell me that the property is in another state. So a will or revocable living trust, either way, you can do the exact same type of planning and say, upon my death, this is who it goes to, this is who manages it. You can set up a trust for somebody else in a will or revocable living trust. You can do the exact same plans. A will is filed with the court, the trust is not. They are tax neutral. There is no asset protection planning. It is just a document that says, this is what happens when I die. The trust does say what happens while you are living as well. But with a properly drafted power of attorney and will, you get the exact same benefit as you do as a trust. So you're doing your estate plan, whether you choose a will or a revocable living trust, either are good options, but an LLC isn't going to do anything if you're living in that place. But stock portfolios, I would encourage not to have a beneficiary designation. I would encourage you to have that flow through your will or your revocable living trust to say where those assets go.
Okay, versus just like mine's just transferable on that.
It depends. Yeah. If that's what you want to do, great.
Yeah.
That accomplishes it. But if you want to protect it for your child, if you want to provide creditor protection or tax planning for your child, no, don't give it to them outright. Put it into a trust for their benefit where they're the trustee. You can't.
My child's 44.
That's okay. You can't, when you do a trust, you can't tax plan or creditor protection plan for yourself, but you can for the next generation when you set up a trust for somebody else. So you can protect it from your child's ex-spouse.
Okay.
But if you give it outright to her and she gets divorced, a court can. Okay.
So what I'm saying is, do you put, so you're saying my will that's very specific and says, and then that I have transferred, but in my will, I could put my stock portfolio in a trust? I'm a little confused, I guess.
Yeah, it's your opportunity to put it into a trust for somebody else. If you just say transfer on death to my daughter, it goes to your daughter. If you say upon my death, my estate is transferred to a trust for my daughter, and you don't have a beneficiary designation or a transfer on death designation, you can do that in your will. You don't have the opportunity to do that as a transfer on death sort of thing. You need to have that structure set up in a will or an RLT.
And that protects her from the creditors? Or?
If she gets into a car accident and gets sued, assets in a trust that somebody else created, not an RLT, somebody else creates a trust for you. So spouse dies or a parent dies and they create a trust for your benefit. There are tax planning. There was a slide in here. Tax planning, creditor protection, control benefits to creating a trust.
Question in the chat, which is it a good idea to file a TOD? What's the pros and cons between will and probate versus trust versus a TOD?
So I personally hate TODs. There is a lot of chat in the attorney listservs of difficulties in dealing with transfer on death deeds. So it is something I recently had an issue where sister died, brother was in charge, and we had to jump through hoops in order to sell the property because she had a TOD deed transferring it to her trust, and then it was supposed to be administered pursuant to the terms of her trust. Dealing with title companies is difficult. So it might not necessarily be that the law is difficult. It is dealing with humans. So transfer on death deeds is an automatic. It gets, it transfers to that person, but sometimes there's going to be restrictions on them being able to sell it. They might make you wait a year before you can actually sell it because they don't want anyone to come out of the woodwork and say, actually, they did something different. So the probate process gives people, there's basically a 4-month time period where people can come out and challenge things. And there's something to be said for going through the legal process there of sometimes it is easier to go through that process and deal with banks and deal with title companies because they then have letters testamentary and they know who they're dealing with as the person they're supposed to be dealing with. Otherwise, they might put restrictions on it or might make everyone sign off on something that otherwise would only require one person's signature.
Second question, that is, I have an out-of-state property that they co-own with their only child. Do they need to set up a trust or a will, work after they die?
They should really have a trust, or if it is a business property that they own with their child, consider setting up an actual business arrangement for that, which might be an LLC. That gets us into tax scenarios that I'm not going to get into today. That's a talk to an attorney situation, but what we want to do is avoid probate in multiple states. So while I said Washington, easy process, that is not true of other states, and you don't want to go through it in multiple states. So every state where you own property, you are subject to probate in that state unless you create a trust to hold that real property.
Last question we ask, and the people in the audience can ask whoever wants to, but, can one have a will probated while alive, like his own will?
No.
Great, that was great.
Mhm.
Well, everyone, both in person here and online, thank you so much for coming today. I think Liberty can stick around for a few more minutes if we have any questions in person. For the online audience, we will be sending this to you all as a YouTube link in a few weeks. If anyone here wants this recording, I'll have a piece of paper in the back. If you could just write your email address legible for me, then I can make sure to get that for you all. Thank you all for coming and supporting programming with Seattle Public Libraries and PMA. And yeah, we will be back next week, same time, but we will be talking about advanced directives. So please come with us then. All right. Thank you.